He doesn't want to work. He doesn't want to go. All right. And then, so we are now recording, Michael, so we can kick off the hearing whenever you are ready.
I know. And sometimes responsibility.
I mentioned it and it felt in your script.
Oh, it's,
Yeah.
I know.
All right, we're just after 10:30, and we will call this hearing before the District 8 Environmental Commission. At this point in time, it is Friday, April 11th, 2025. The applicant, Ronald Rodriguez, is present and will be presenting his application during the process of the meeting. He is seeking authorization for a project generally described as the after-the-fact conversion of 4659 Main Street from retail to a mixed-use building consisting of a 32-seat restaurant, 22 indoor, 10 outdoor, and 1 2-bedroom apartment. The after-the-fact scope of work includes the reconstruction of the back deck and stairs, installation of a cover above the basin entry, the construction of a pergola, the interior renovation work, and that would complete the scope that we are looking at. This application also seeks authorization for the following proposed work: installation of a fence to enclose the existing trash area and the installation of a bike rack. Project is located at 4659 Main Street in Manchester, Vermont. I would next like to introduce those of us who are at the table. My name is Michael McDonough. I'm chair for this hearing. And beside me are Don Miller and Jim Sullivan, both district commissioners. And to my left is Kim Lupchik, further down, and Quinn Mann, who is sitting beside me. I'm going to read a statement regarding Vermont's open meeting law. In accordance with 1 VSA 312, Vermont's open meeting law, I confirm that we have taken the following steps. And that is the reason for all of the setup today. We are providing public access to the meeting by online video conference with additional access offered through telephone. We are using the Microsoft Teams platform for the hybrid meeting. All members of the commission have the ability to communicate during this meeting, and the public has access to listen and, if desired, participate in this meeting by attending in person, downloading the Microsoft Teams application, or by calling in to a toll-free number provided in the meeting notice. In addition, we have provided public notice of instructions for accessing the meeting. We previously gave notice to the public of the necessary information for accessing this meeting, including how to access the meeting using telephone or Microsoft Teams in our meeting notice. That document, including those instructions, are also provided in the meeting notice on the Act 250 database. Now we're going to review some housekeeping matters. This meeting is subject to Vermont's open meeting law, as we've stated. By participating, you are consenting to being audio-visually recorded and for that recording to be published in the board's online database and/or YouTube channel. Please be aware that the microphone that is used to record the hearing is extremely sensitive. We've already discussed this with most of the people in the room. It will pick up on and record whispers and side conversations. Anything that is recorded will be published as part of the public record. So keep your whispers to pertinent facts relative to the hearing. I think that would be the safest thing. In addition, any written information or exhibits provided to the commission or Act 250 staff regarding official state business are considered public records and will become part of the permanent record to be published in the board's online database. If you would like to speak during the hearing, please raise your hand and wait to be recognized by the chair. Everyone will have a chance to present their evidence and respond to the information presented. There is no need to interrupt or talk over the individual who is currently speaking. I want to parentheses a bit here. The parties have been together in a previous hearing. They are very committed about their position. And that commitment sometimes makes us a little anxious. So I'm asking that we all respect that component of listening to a speaker, and when your time is made available, you speak. And I think the main purpose is to make the hearing flow sooner, quicker, so that we don't have to be here all day. Now, the purpose of the hearing. We are charged with collecting evidence as to whether the project meets the requirements of Act 250, and based upon that evidence, decide to issue any or deny the permit applied for. Regarding attendance, we will take a roll call after we have everyone signed in. Kim is working on that now, I believe.
Thank you, Ken.
We will then call a roll of attendance for all purposes participating in the meeting. So be sure that you have signed up if you haven't yet. Is there anyone here in the room that has not yet signed in? Are we all, everybody's all signed in?
No, we have to.
Oh, we're still working on it. Yes, okay, all right. So we'll let that proceed.
You can go to the conflict of interest.
Yeah, okay, that would be a good idea. Yeah. Okay, I'm jumping ahead to conflict of interest while we take care of our sign-ins. And the first part involves disclosures of conflict of interest. The commissioners have reviewed all the materials submitted with the application, in part with an eye toward identifying any conflicts of interest that a commissioner might have. We are not aware of any conflicts of interest that need to be disclosed at this time. Ex parte communications. Outside of today's proceedings, may I remind everyone that all communications, whether by letter, email, telephone, or in person, must flow through the district coordinator, Quinn Mann, and not through other parties or commission members. So Quinn is our conduit to and from. You may want to participate in these proceedings as a party. Overview hearing process. I'm sorry.
So maybe
Yeah, okay, we're close. Yes, that's right. Yeah.
roll call will just be in front. Just who attends. That part of the roll call is just anyone who's
While we're still in pause, there's a restroom to the back and to the left. Anyone requires. There are also public restrooms down the hallway We all get in there.
And I will take this opportunity to say, staff actor does serve as the break room for staff, so there might be folks coming in and out of the room. On this night.
So, help me if I do any mispronunciations. We have Jean, is it Cole?
It is.
Yes, okay. And, you are
I'm their neighbor across the street.
a neighbor, yes, yeah, okay, all right. And it would be helpful if you indicated what's your representation. HT, can someone help me with this?
I think it's Adam Dorkin.
I'm sorry, Adam Dorkin, yes, yes. And you're here,
As a joiner.
Yes.
Co-owner of Irish Plaza.
yes, thank you. Frank, David? Parent? And you're here for?
Irish.
Yes, okay, all right. Karen Uriak? Hannah Dworkin? Lawrence, is it Sloan?
Slayson,
Slayson, sorry.
attorney for High Ridge Plaza LLC.
Yes, thank you. Ron Rodriguez?
Yep. Listen,
Yep, and the,
applicant,
yes, okay. Matt,
Singerbrand,
Sigerbrand, thank you.
I'm a representative of the applicant.
Yes, okay. And Michael, is it Boyer?
Buyer,
Fire, yes,
applicant, engineer.
yes, okay. Anybody here that didn't get their name called? Okay, so we're good with that piece. So we'll continue with a couple of details of the process. And next, we're going to talk about overview of the hearing process. Commission's charge is to collect evidence as to whether this project meets the requirements of Act 250, and based upon that evidence, decide to issue or deny permit applied for. You may want to participate in these proceedings as a party. Party status is important for at least two reasons. First, a party may introduce evidence, bring in experts or other witnesses to testify, and take part in the arguments as they are take place during the hearing. Second, only a party may appeal our decision to the environmental court. Does anyone have any questions at this point about the process we will be following? Administrative oaths. I'm now going to ask anyone who thinks that they might address the commission during this hearing to swear and affirm that they will tell the truth. Accordingly, anyone who expects to address us, please raise your right hand. Do you solemnly swear or affirm that the testimony or evidence that you shall provide relative to the consideration of this application shall be truthful, accurate, and complete under the pains of penalty of perjury? If so, answered, I do.
I do.
Thank you. Now, we will ask the applicant, Mr. Rodriguez, to provide us with a overview of the project. And we are looking for general view and specifics as they may pertain to your application.
Okay, I'm going to provide the initial testimony.
Sure, thank you.
Going to stand at the podium or?
I'm comfortable with sit down. Yeah,
Okay.
but please state your name and representation again.
That's an representative of the applicant.
The original application was filed in March 2024 and deemed complete after the third submission on February 5. Approval is sought after the fact to comply with Act 250. Over 10 years after completion, with no complaints or issues. New construction, including a fence enclosing the trash area, and installation of a bike rack, complies with the Act 250 committee recommendations from jurisdictional order 8-286. Curbing was never removed by the applicant. The original curb was removed to make room for a handicap access ramp in the second floor of the previous owner. This ramp was replaced by a private deck in 2013. Curbing installed to close the gap where the access ramp used to be. The straight line stopped meaningfully impede further the shared park. June 6, 2023, the Natural Resources Board issued a notice of alleged violations specifying 3 directives: removal of the shed and potted plants, restoration of the curb, the application for an amendment to LUP Series 8B0334, which we failed to comply with. Due to the fact the applicant's first submission was deemed incomplete, the applicant took services of a licensed professional engineering firm, but was unsuccessful in retaining a firm in time to comply with the innovative directive. Once the applicant secured the services of IRA Lee, the licensed firm, for completion of the application, it was promptly completed. The applicant paid the civil citation on January 6, 2025, told to apply for a waiver to remove the violation, fine proceeding. Multiple restaurants operating on the premises without parking issues between 2010 and 2015. Currently, Non's Kitchen serves fewer meals per day compared to previous, resulting in a measurable reduction in parking demand by at least 33%. Any perceived increase in congestion arises from a fully occupied adjacent shared use building, specifically from 4 therapist offices generating a substantial increase in daily vehicular trips. Our estimate is plus 32 trips per day, Monday through Friday, assuming each therapist office sees 1 client per hour. 4 additional offices in the shared use building add to this drastic increases. These tenants may also be seeing clients throughout the day. The primary contributor to parking congestion is the shared use building. At any given time, Monday through Friday during regular business hours, a minimum of 15 vehicles owned by those tenants and or their clientele occupy the parking lot. High Ridge Plaza could mitigate the congestion by directing tenants to alternative parking locations such as the Gap or Hampton Inn, but has thus far refused to do so. The current rear deck and stairway configuration does not further encroach upon the right of way than the handicap access ramp did and remains within the original boundaries of the established right of way. No apartment building exists at the property, contrary to some other statements made. Rather, it is a single family unit occupying the 2 upper floors and generating minimal daily traffic. Applicant has renewed our insurance coverage and is actively pursuing additional policies, specifically addressing parking area liabilities and other things pointed out by High Ridge. Applicant is compliant with all town regulations regarding handicap access and is in the process of preparing a concrete retaining wall that has leaned into the handicap entryway to ensure the building meets ADA standards. Applicant is willing to comply with the requirement for an ADA compliant parking space, but has thus far been unable to do so, given High Ridge Plaza's refusal to discuss the shared parking arrangement. The handicap entryway at 4659 Main Street is in the process of being remediated to ensure patrons can safely and easily access the restaurant. Given that the lowest slope providing access to the entryway is located at the southwest corner of the disputed parking space, this further reinforces the need to establish a more protected pedestrian walkway via the installation of the bollards and bike rack around said space. The property, though eligible for inclusion in the State Register of Historic Places, is not presently listed on that register. Recent property modifications align harmoniously with local aesthetic standards. Maintenance activities, including necessary repairs to historical infrastructure, are standard for structures dating back to 1842. By contrast, High Ridge Plaza maintains numerous aesthetic violations, including unauthorized signage and poorly coordinated outdoor seating arrangements, negatively affecting the shared parcel's visual integrity. Current liens placed on the property for maintenance of the shared parking area are being actively disputed due to their improper filing and a general lack of consistency regarding what High Ridge Plaza considers in scope, often going far beyond the typical products and services required to maintain the asphalt. The conversion from retail use to restaurant was done in full compliance with all state and local regulations as they existed at the time. All permits, inspections, and approvals were provided in accordance with the town of Manchester's rules and regulations as is clearly shown in the project exhibits. It was not until 10+ years after work had completed, the state informed both applicant and High Ridge Plaza that the parcel fell under Act 250 jurisdiction. In addition to the above, the facts and material for this. In the summer of 2022, the applicant listed the property for sale. In early January of 2023, High Ridge Plaza submitted a letter of intent to purchase the property at 40% below asking price. In late January of 2023, High Ridge Plaza filed their first of 4 complaints to the Vermont Division of Fire and Safety. Applicant began remediating the violations identified by the inspectors that came in response to this complaint. In August of 2023, applicant chose to delist the property and listed the commercial space for rent, at which point the now owner of Nong's Kitchen expressed interest and negotiations to reach a rental agreement commenced. Since that time, occupants of 4659 Main Street, myself included, have been unduly burdened by High Ridge Plaza's continued attempts to shut down the restaurant by any means necessary, taking away, for all intents and purposes, our livelihood. These continued attempts have been resoundingly futile and often go against the established and re-articulated opinions of the town and its administrators. These latest attempts to use the state's resources as a battering ram to forcibly remove applicant from the property through the imposition of financial, physical, and emotional burden should be viewed as inflammatory.
Does that?
That concludes my statement. Yeah.
Now, we have that, a written copy of the statement, do we not?
No, so him saying it, puts it on the record that if you so choose to want to submit that. in
It was
written form-
submitted, yesterday with the certificate of
Submitted
service.
as evidence.
Okay, I haven't looked at
Yeah, it's okay.
I think yesterday,
Okay.
so, do you mind if I just say?
No,
a comment? So I do, just want to, frame this proceeding, through this proceeding. So,
Thank you. And thank you for your introduction to the project. We're now going to talk about petitions for party status and any other participation right. We are now going to ask for any party status requests, and we'll provide further explanation of that party status process. So are there any specific requests from any of the parties for party status?
So, Mr. Chairman, yes, if I may, I'll stay seated as well. We've submitted a joiner's memorandum in support of party status. I believe High Ridge Plaza through Karen Garriak and Adam Dworkin submitted a preliminary party status petition as well. And just in terms of reference where we're standing today, this will have to clearly, this will be in evidence later. But High Ridge Plaza owns parcel 3, owns parcel 1. The applicant's properties are trying to do it. But clearly in the joiner, with the shared access, shared parking, shared stormwater management, and the like. So in terms of, and you have the memorandum in front of you, but if you wish me to just briefly to make the record in terms of the criteria that we would present evidence on or wish to participate as the applicant goes through the criteria today. Criterion 1B, waste disposal, and criterion 4, soil erosion. You'll find that on page 7 of the memorandum. I'll digress for just a minute. The introduction of the memorandum sets out the application and the enforcement history. The second part sets out the main legal documents that limit the parking spaces to the applicant to 12 and provide that there must be an unencumbered, unobstructed 26-foot right-of-way. And those legal documents will They've been submitted, I believe, on site, but I've got originals here today that will put in evidence. The reason we're seeking party status of 1B in waste disposal and soil erosion, because the stormwater discharge pattern of the site has been altered by applicants' movement of the curbing, notwithstanding his, what will be apparently his testimony today. We will have contrary testimony and photographic proof of where the original curbing was. And with the removal of that, Mr. Kimmick, the enforcement officer, required that it be replaced, and it has not, and that will be our testimony, followed by proof. Because that alters stormwater discharge is consistently considered under criterion 1B and criterion 4. And in the JO opinion rendered by the district commission that preceded all of this enforcement, it was found that there could be impacts under waste disposal and criterion 4. So we're piggybacking that.
Sir, if I may?
Yes.
I believe that you have adequately explained your reasons for party status on those two criterion. And I don't think it's necessary for us to proceed with the facts relative to that.
So,
So if you
yeah.
want to conclude your request for party status.
okay, so all of those in the memorandum, they all been reasonably established in the board's opinion under 5 and all the others that are listed. See, that was just criterion 1B and 4.
Oh, so you were continuing?
Yes, I am, sir.
Okay, I'm sorry.
Yeah.
But please, list the party status request and try not to give testimony regarding that other than stating the reason for the request.
Fair enough. I appreciate that.
Thank you.
Under criterion 5, transportation, because we share access, shared parking spaces, and the memorandum goes in substantially greater detail why the particularized interests of the adjoiners are impacted under criterion 5. Yeah.
Is it 5A or 5B or both?
Both.
Thank you.
Under criterion 7, municipal and government services. Under criterion 7, Act 50 traditionally considers whether or not all public building permits, life safety codes and regulations and ADA compliance are satisfied. In fact, I believe under the Schedule B, there's a form for that in the guidance documents. We, as an adjoiner, were directly affected as to whether or not the building complies, whether the municipality has to provide services to a non-complying building, and whether or not there's adequate handicap access, and both in parking and in terms of physical access, which affects our property. And briefly, because there's only one handicap parking space, and when 2 are required, the space that was set aside by Highland Plaza has been utilized. Now there needs to be 2. Criterion 8 is the aesthetic historic sites, the Richardson House, and whether or not this commission can determine whether the alterations are compatible with the building's historic qualities. And I don't need to address that further. 9G is public utility services. And any time under Action 50, there's shared private road access, sewer and wells. Action 50 generally wants to determine whether there's sufficient funding, whether an HOA has been established, and whether the municipality is protected in the event of failure to maintain. And we go there in terms of our position will be that the applicant has not shared in the expense of maintenance, repair, and replacement. We can deal with that later in terms of the details, but High Ridge cannot be left with the financial burden. And if it were to be failed, that would become a town burden potentially in terms of the other public uses.
Again, you've stated your reasons.
And under criterion, and I appreciate that, you'll have to move me along. Under criterion 10, the local plan speaks to traffic generation and parking. We quote the section of the plan where we believe has been violated or at least needs consideration by this district commission. In terms of what we're quoting now, just on the grounds, the actual on the grounds conditions, not the theoretical. With that, those would be the criteria we seek party status.
Thank you very much.
Yeah, just clarification. The
And 9A was impacted growth.
Yeah.
I'm not aware that that's, they're okay with that impacted growth. Yeah, you apparently you requested for status. You want to look for the original request? Oh, because of that.
So is the impact to growth criteria is about economic and growth.
On a more general nature.
So you no longer want to like that is under 9. Yep. Well, so yeah, we can talk through, I could just say, so 9G wasn't included in the original petition, the written petition for party status. So at this point, the commission can either choose to go into a brief deliberative session to talk about preliminary, party status determination.
Can I ask one particular question? So you are both, you have established party status and you are asking an additional party status as you just described. Am I understanding that correctly?
I think they're, if I may, they're complementary. In other words, what was submitted and what has been handed to you today is supplemental to the applicant's original petition. They did not have counsel.
Right.
They did not have counsel at the time.
Understood.
And so today, to the extent, for example, I don't believe the applicants originally requested 1B. As attorney, I recognize that stormwater is a 1B issue. And I'm not certain that they understood that shared utilities constitute private utility. So that's the reason for those additional supplements today.
Thank you. So, commissioners, if you have a preference one way or the other, I would like to deliberate on the requests, particularly given the number of criterion that are being sought. So, reasonable to you. So, we would like to declare a recess, and we will deliberate on the request for party status. We'll try to be as quick as we can be. It's 11:05. Do we want to establish the party?
You want to do 10 minutes?
10 minutes sound good? I don't.
Yeah, 10. I think that's
I'll
good.
take 10. Okay.
No,
No, we can step into the back room.
11:15,
Yeah.
we'll go back if you wanted to.
Yes, yes.
Also before we read, come back review.
10 minutes on the dot. Reminder, we're back on recording. And our purpose right now is to declare the granting of preliminary status relative to the request that the applicant had made. And in the interest of time, I'm simply going to take the section that we're granting party status, preliminary party status to. And what I want to note for all parties is that preliminary status is just that. It can be amended. It can be eliminated depending on the evidence that we are going to be proceeding. So the party status is granted on 1B, preliminary party status is granted on 1B, 4, 5, 8, 9G, and 10. We are holding off on 7 at this point in time. So if there be any questions from either the applicant or none. Okay, all right. So we are now going to proceed with the review of the criteria, granting opportunity for both the applicant and the complainant, adjourning, yeah, to present their proposals relative to 4, 5, 8, 9A, and
1B and 10.
1B and 10, yes. One thing we do want to say is because of the nature of this application and its after the fact nature, and I think it has been stated in the supporting material, our focus is on that change of use and everything that results from the change of use. And so I would ask that presentations respect that particular aspect of our review. That is the after the fact change of use, which has impact on a number of criteria. But again, please stay focused both ways on that change of use. So let's begin with criteria 4, soil erosion and drainage. And we would ask the applicant to provide whatever
Chair,
presentation.
Just to keep sort of my head keep straight, did you want to start out with 1B?
Oh, I'm sorry. That's right. We did have 1B. I'm looking at the other.
And those can be put together, and
1B
under
and
this
4.
case, they're both doing stormwater, so it can be.
Yes. Yeah, my mistake. Apologies. Yeah. Thank you. So we're starting with 1B.
And you're looking for a statement from us first, or?
From the applicant
Okay.
and then from the adjoiners.
So this is. Okay.
Yeah, so the curbing issue, right, with soil erosion and runoff, we have not made any material change to curbing or anything related to that area, other than to replace the asphalt that was removed as part of the, with switching the handicap access way to a private path. That was done a number of years ago. The asphalt that was placed there is aligned with the recommended placement that is in that jurisdictional opinion, and any other actions that have taken place that have increased to erosion or runoff are out of our control. They include that take place around the property or clearing trees. We really have no further state to make out in there. Okay, I do want to say something like that.
I'm just sorry, I'm on my different.
Okay, Ron Rodriguez. When I purchased that property was exactly that for the pergola. We made no changes at all to that. Parking lot was put together like that under the old 1997 F-250 that was approved. There were no changes there. When the handicap access was removed, which we viewed it was a little walkway, that piece of pavement had been moved so that you could walk, bring the wheelchair up in that. When it was brought to the attention, when that this jurisdiction, that we were under, that property was under jurisdiction of 250, and it was brought to my attention, to the Dorkins' attention, it was reported that those pieces of curb were missing and that some of them had basically eroded through the year. And then that's when I was contacted by Quinn Mann. That's when I was contacted by Chris Kenneth. And that was the only change that I made to that part. We're addressing the asphalt. There was nothing else. I didn't change the slopes. I didn't change, every tree that is on my property is still there. I didn't cut down one tree. And that's, so I made no material changes at all to that. And then when Chris Kinnick, he sent the photographs of where I needed to fix the curbing. I looked at some alternatives and I put that curbing exactly where I was told to put it. And that's where it is. And that is, again, no change to drainage, no change to the asphalt, no change to the parking lot, and no change to the slope. And that's my statement regarding that.
Yes, okay, thank you. And procedurally, what we're going to do is allow the applicant to make their statement. Then we will turn to the adjoiners to make the statement relative to the same criteria. And then we will give opportunity to the board to ask questions. Okay,
So we're talking about 1B and 4.
All right, so,
Correct.
Yeah.
yes,
Okay. I'm just gonna stand. 'cause I
so
feel-
Karen, I'm gonna ask you some questions. I'm gonna give you an opportunity. So again, I'm Larry Slason, attorney for the adjoiner. Karen Garyak, one of the members of the LLC, and Karen, you're under oath. Karen, I'm just gonna start with this question. Since you have occupied the property at High Ridge, have any changes occurred on the site of lot number 2, the Rodriguez application site? Have any changes occurred that have changed the stormwater discharge pattern or contributed to erosion, in your opinion?
The back wall is just failing. There wasn't appropriate curbing there. The deck now has, but no, like Mr. Rodriguez didn't change the parking lot. I don't know. The original curb is supposed to be along that. There was no curbing for a considerable amount of time, and we had to replace that curbing.
So let's get to the curbing. Has curbing been removed since Mr. Rodriguez acquired the property?
Can't say if it was Mr. Rodriguez or the Memorial or the Walnuts, but curbing was missing when we purchased the property. removed it. I can't specify.
Can you identify what section of curbing is ordered to be replaced as a result of the enforcement action?
The entire behind the back of Mr. Rodriguez's. If you look at the original pictures, that concrete wall is tipping, right? Tipping back toward the building. So the curb has actually sunk. Does that make sense? I have pictures.
I
Can
was going to
show-
say that. Do you have photographs either that you'd shared on the database or that you have photographs you would share with the commission today showing the location of the original curbing?
Yeah. Okay, so if we go. Can you pull up exhibit 024F? And in your file folder, it is folder number 5. You want to pull it out.
Do you have any hard copies here
Yep, each commissioner has one.
in their binder?
Uh-huh. Okay, so that's the original stairs that were put in place. If you look, you see how high that curbing is? And it goes all the way behind. But now, if you remember correctly, that curbing's dropped like 3 to 4 inches, and you can see more of the exterior back wall than what is represented there.
Do you have another photograph from the other underside,
Yep, continue to go down.
the one that you showed me earlier today?
Yep, that is the Walners, when the Walners put in the handicap ramp. That is the handicap ramp that they put in, okay? Then continue going, okay. Right there, you can see there's no real curbing in that picture. It's disintegrated or somebody chopped it away. That is where Mr. Rodriguez hatched it. As per the NOAD. Now, right down to the neck. There, he just glossed over it. Now go down to the neck. There, you can see the concrete or cement blocks tipping. He just glossed over that. Okay. Going. You can see a crack in the cement wall where water is allowed to go toward the building, creating the sinkhole. You can see how there's no curbing, and that's his where he was supposed to put in curbing.
Well, when you say supposed to put in, if you look at that photograph, Karen, is there the original curbing, is that against the concrete blocks that we see?
Correct. That's
Okay, down in the gully.
down in the gully.
Now that's the original curbing and that's still there.
Correct.
And that's what you pointed out to the commission on the site visit.
Correct.
Okay, go to the next picture to show where that came.
So this is the line, the red line on the left-hand side would be the line going straight back to the cement wall at an angle. The other line would be where the curbing should have been installed, way back there against the cement wall.
And where's the photograph you showed us earlier that we were looking at down below?
To go down. A little further, see there, you have the line. Supposed to go back at an angle. There is no curving. This is all eroded. It's crumbling back. This line's supposed to go back. Here is the original curving right here.
So is it your,
We just made a hump. A hump. See how it's different than the old curving? This is just a hump that you tried to replace. That's all.
I want to make a statement. The question of these failed elements. And I think we've got to maybe look into this further, but we believe that that is an enforcement issue and said enforcement is now still in play.
Specifically, the restoration of the directive to restore the curbing, that was an enforcement directive. And so I just want to remind folks that this commission does not have authority over enforcement actions. So this is something that was directed, this work was directed by enforcement. That's all.
Chris told me that, I'm not, yeah, Chris told me to bring up this information here, so you are aware of the issue.
I'm just reminding you what they have authority.
Yeah, it just wasn't installed.
So it's, as I understand, it's your testimony that the original curbing ran along the concrete blocks going, back, where's the one with the red line? The anchored line. That one there, that one right there. So it ran along the back concrete blocks and then eventually came up and see the curbing. It's the same type of material that's observed today, right?
Correct.
Now, so having in mind that that's a compliance directive in the chair's direction here, what they need help with, Karen, is if the curbing were installed in its original location against those back, against the back concrete, how would that improve either the use, safety, or function of the shared areas?
Well, the actual parking lot is collapsing. You can see it's crumbling. You see where the grass is? It's rolling back and crumbling. Before my asphalt guys come to fix the parking lot, everyone's requested that that back wall is being held in place by that kitchen expansion.
So help the commission understand how the collapsing and the erosion of the parking area is attributed to conduct, the applicant's conduct, if that's your opinion.
That's my opinion. It's a,
If I may, we'll come back. And we're gonna, let's see.
You're right. Yeah.
I still raise the question of, enforcement, and inadequate response to enforcement requirements.
I'm sure.
And I think that falls under the enforcement question.
It may. I'm trying to move beyond that. I'm asking about the impact. I'd like to have Mr. Parent, the engineer, speak to that from an engineering perspective. We'd like to suggest how the curbing should be installed. That's not an enforcement action. That pertains to work the applicant needs approval for. This is all after the fact work. And if the curbing is not in a location that's appropriate for stormwater and engineering, then I think this commission needs to consider that.
My only concern is that if the installation of that repair falls under jurisdiction and not this body, I would think that the inadequacy of the repair, failure of the repair to do its job would still be a component of enforcement.
It may be a dual role, but in order to find your 1B and that the applicant hasn't contributed to soil erosion, I think this commission should hear from Mr. Parent.
Yes, please.
And I think you're getting to what I wanted to ask. So, testimony is kind of the question is like, is that change to the curbing was that, is that something that was and I think within years how specifically would it be that formula? The water is still going toward the back of the building down parking lot. What material that would change?
That's a good question, Mr. Commissioner, which is what I'd like to ask our engineer.
And it's the summary. So I think there's two issues going on. On the removal or deterioration of the central water gets the path in between the cracks. As water moves down to that area, it's causing them to tip. And that's what we saw today. So if the curb was installed, at this point, that concrete wall needs to be fixed because it's tipping. But if you had a straight new concrete wall where those blocks are, and you had an appropriate curb put back in front of it, at that point, stormwater runoff would no longer hit the back of that wall and it would stay upright and intact. Because what eventually could happen is if those concrete walls keep tipping and tipping and tipping, they fall over, the uphill parking lot is going to slough off. And it'll have, at that point, you won't be able to drive through it. You'll have to get it fixed. So I guess what I'm trying to say is if the concrete block wall was fixed properly and you had curbing up to that preventing water.
And where, in your opinion, Mr. Parent, would you place the curbing to preserve the integrity of the parking area?
I would just put it outside of the 26-foot here. Somewhere between the edge of that shared access and the bathroom. I guess if it was as close to the wall as possible, that's going to limit the amount of water that could potentially notwithstanding the enforcement questions that we have raised. And I presume that you may have other things other 1B. You haven't completed that process yet. But I would like to, because we're staying so specifically on this component, I would like to give the applicant the opportunity to respond to that specific question, because I'm afraid it might get lost in our other deliberation.
That's in red, we look at our here.
Yeah, please do. Michael Byer for the landowner.
I'd like to pose a question as to where the curb is presently located, where it was previously located, and was that as per the original Act 250 approval? The Act 250 approval would give you a certain amount of impervious area that was paved, and to direct the stormwater runoff properly is if the curbing as shown and presently out in the field that you saw is in line with what the original Act 250 boundary was for the asphalt, and whether it's failing or not becomes an enforcement issue, not a violation. So my opinion would be that everybody's is the same opinion. You need the curb to direct stormwater down. Whether it's in good repair or not is an enforcement issue. And if the joiners are recommending that they move the curb farther under the deck of the wall, will that now require additional or amended Act 250 for the entire high ridge approval? That's my worry, that if you do increase the impervious area by extending that parking lot, does that require you to go all the way back and get a new approval for the entire parking lot? Something they want to kind of avoid or post the line on. But that's our opinion.
Any comment from the commission relative to that?
Just one for clarification. So we saw the curbing out there. And the testimony here is that water is hitting behind concrete block. So does that mean that the curbing where it is not keeping the stormwater away from the back of the building and the concrete blocks? Does it overtop it or does it?
I'd like to, answer a little bit. If you go back one picture, yes, that picture now. So that curving, if it was a little bit back further or not, I wasn't aware because obviously you saw the way it looks. I had the curving put there because that's where it made sense to direct the water further away from the wall, but not to direct the, right into the cement blocks. It made sense that the water should flow, the easiest flow, which is further into the parking lot than directing it into the building and that. So that's where I thought it was. And we're talking about a section that is 5 feet. Karen has said that all the other curbing is, as far as she knows, was the way it was. I didn't alter it. I didn't change it. That piece eroded and I put that piece there. And by the way, the kitchen is not holding up those blocks. That is just a small wall because there's a walk in there. It is not part of the building. It has no integrity to the building.
So this map, this Act 250 map, that would show you the 26-foot right of way, and that's where the curving was. But it's all closed out. Or was it town file? No.
Have you pre-filed that in the database, Karen?
Yeah. You have it. Yeah. Exhibit with, site plan. Also site map 024, and I think it's a little 0 after, the also site map. And so are you
Is that the LSP survey?
this is the LSP survey.
Yeah, so I can speak to that when we get to criterion 5, but I'll lay the groundwork preliminarily. The agreement that establishes the allocation between 12 spaces for lot 2 has attached to it the LSP survey and the reciprocal easements, which will be placed as evidence later today, refer to the 26-foot right-of-way as being laid out as shown in the LSP survey. So the LSP survey is an integral document which is legally binding on the parties to this shared parking lot. And so if that answers your question, it's coming in evidence today, and that is an important document.
One little reminder to everyone, because we're all anxious. Flag the hand, before we. Gonna go out on a limb here, to suggest that, I think we have an adequate understanding of the condition that you described versus the description that you described. And unless,
I think so. But I want to summarize what I think is the key point to make sure that I have this right. Because we're dealing with stormwater and erosion and the impacts on the criteria in the project. It sounds to me like that the issue is that stormwater getting behind the concrete wall and destabilizing it and potentially causing it to lean in or collapse, which would cause the shared parking lot to slough or collapse. Is that kind of like the issue in a nutshell? Okay, and then the question of whether the curbing is adequate or not is that an enforcement issue or a criterion issue is something to talk about. Yeah. Okay.
So may I follow up quickly?
well, I'd like to ask one additional question. Refresh my memory, the when, relative to the erosion, remind me when the deck was constructed?
The original deck,
Well, the deck we're looking at now.
Mr. Rodriguez would, so there was a handicap that was done, I'm gonna say 95. And then Mr. Rodriguez changed it. And then in 2023, he had somebody else, the outermost posts, because the deck was collapsing, he had those additional posts installed.
Would you, yes.
The deck was
your version.
constructed, the deck was constructed around 2013.
Which would,
The entire deck.
yes,
The handicap structure was removed and the deck was constructed then, at that time. So you're talking about, 12 years ago.
which theoretically, does that predate the failure of the curbing?
Yes. It does. It
All
does.
right. Did you have an additional point relative to the curbing issue? Because I'm going back to my thought that I think we've got a pretty clear picture. It comes down to the legal responsibility. But did you have an additional point?
Well, I just had the last, a question for our engineer, Mr. Parent. Do you have a professional opinion whether the curbing needs to be repositioned to preserve the shared parking area?
I think we'll get ahead when we talked about parking, but it appears that at least a portion of that curbing is within the shared access right of way that is supposed to be for parking and vehicle traffic. So I think some of that juts out into the right of way.
But we'll get to that.
But yeah, that's coming up.
We'll get to that. The question is limited to stormwater. Do you have a professional opinion whether the curbing needs to be repositioned to preserve the shared parking area?
Yes, I think the curbing should be, it's not just the curb. In order to properly fix it, the leading wall has to be brought straight. Then fill has to be brought against that because the fill has been washing out. That needs to be brought up to grade. And when you've done that, you can add the curbing closer to the wall. And by doing all of those things, it will prevent the issue of the parking lot eventually sloughing off in the future and being damaged.
And I still go back to the question of whether that is an enforcement issue or whether that is relative to this hearing at hand.
So again, I want to get your attention so I don't jump in. And when we get to criterion 5, there may be greater clarity. It's a little tough when we're doing this piecemeal because obviously we know where we want to go.
Yes.
But I think Mr. Rodriguez would agree that under the contractual agreements and the reciprocal easements that limit the 12 spaces and the shared maintenance, there's a shared obligation to maintain the shared parking area. And that's a legally binding on the applicant. So what we're pointing out, we're attempting to, and maybe not as precisely as I could. What we're attempting to point out is if in order to carry out the legal obligations and to meet the requirements of 1B, no soil erosion, to maintain this common area that we all use, he needs to make some repairs to his wall, bring in fill, and reposition the curb. He started all of this with all due respect. I don't mean to make it personal, but this was all started, all due respect, by an alteration to the curbing. And then from there, one thing leads to another. And so now that brings up the 1B, which is squarely within your jurisdiction. And whether or not the curbing is then eventually done accurately could be an enforcement action. But I don't want to worry about enforcement today. I want to make sure that parking lot remains stable and that stormwater is discharged appropriately.
Heard, taken into consideration.
I would just.
One response to that.
Yes, I do. I do. it is almost like all the blame of the water that runs down through that parking lot, through portions that are not my property, are my fault. And that I'm causing this horrendous damage to this parking lot because of this little section. You were here a year ago when we did a total inspection. And we also saw where the source of a lot of that water that comes down through that asphalt, through unpermeable ground. And you also remember through evidence that a lot of trees were cut, not on my property, that added, at the end of the property, that added to the flow of water coming down that parking lot. And there was never any concern about it. And that's where this is going on where it shouldn't go.
I just have
Are you commenting?
on his
I
comment.
really want to, on his comment.
Am I allowed to? If not, I'm fine not
Well,
to speed it along.
if it's to the point of disputing something that he has said, at some point, it boils down to the interpretation of this commission, as to what makes the most sense. And I think on this curbing and drainage issue, subject to your reference to 5, I think we have a pretty good picture and would be inclined to want to move on to the next. Do you have a next topic under 1?
The plastic on top of the pergola. If you can pull up exhibit 024B, please. Oh, maybe I'm sorry. Sorry. No, Ken. Sorry, Ken.
I know what you mean.
Folder number 1. If you scroll down to the next page, that plastic comes out considerably over the parking lot. You can see the icicles. Oh, sidewalk, sorry, sidewalk. Then scroll down to the next picture. You can see this more clearly. This was like a reversal day, but when the sidewalk is cleared, right, you have a warm day and there's snow on top of that plastic, water is dripping down onto that sidewalk. It freezes at night. It causes a slip of ice to form. I think the plastic needs to be removed.
I have one particular question, and I would be interested in both your answers. Is that a municipal sidewalk?
Yes, it is.
I'm going to answer that question. I will reply to
request.
Seeming that this was brought up, I think it should be addressed now. And I'm just going to, the Dworkins wrote a letter to Peter Brabazon, the zoning manager, and where they said they had a problem about where the pergola was located, somewhat, from the 20-foot line or from the center line and that. This is what Peter responds to them. So, yeah. This was addressed March 21st, dated March 21st, this year, 2020.
Could you simply make reference to the letter and provide it?
Oh, yeah.
For record? And,
okay, so first, Ron Rodriguez.
Can you summarize in a couple of?
And this was, this is, following extensive discussion. The letter was written from, Karen Jeriak and Adam Dworkin concerning the pergola being on town property. And their letter was written March 14th, 2025. Peter responded. He said, this is, it only take a minute to read. He said, "Dear Karen and Adam, the town of Manchester provides the following response to your letter dated March 14, 2025. Pergola permits.
Sir, I'm sorry. I've asked you to summarize and provide the document to us.
What he says is,
We're also under criterion 4 and 1B, right?
okay,
Understood. She brought up the pergola, we're responding, right? The net is that they complained to the town that the pergola was on town property, and the town's administrator responded that everything is okay.
he said, just to say, he says,
I accept his reference.
the sentence says nonconformities are existing and allowed to continue per section 8.1 of the ordinance. The DRB's decision, related permits were not timely appealed. The town cannot modify the permit conditions nearly 10 years later. And it was approved as it was back then, as it is today. So
That references the pergola.
that's to the pergola.
The issue that was raised is, water and freezing. I think those are two different issues. And I would say that it's very clear, you made it very clear that water is coming off that roof structure. That referenced the position of the pergola. It didn't reference the concern about ice building. So, I would just like to take that to the record, and
A remedy in this situation could be to cut back some of the polycarbonate, over the bushes.
may or may not be.
Yeah.
But I think, Charles, I'll give you one last.
Yeah, the reason we brought this up is because you asked if it was a municipal sidewalk, right? And the municipality, right, in charge of, run by Peter Bravazon,
Yes.
has reviewed and basically said everything's good to go.
All right, that's your testimony. And, is there anything more to add on?
Not to that picture, not to the pergola. I have another one.
There actually is something to add to the pergola. I have a question with you. Yes, there is.
Is it in reference to the water and the freezing situation?
It is.
Go ahead.
So under the water and on the municipal sidewalk, I think that would implicate criterion 7 potentially, as we reconsider party status going forward. The question for Ms. Gariak is, does the Rodriguez Lot 2 extend to the sidewalk?
No,
Okay, and do you know, and do you have any, and you may have the permit, do you know whether the pergola was approved based on representation by the owner of Lot 2 that the property extended to the town sidewalk?
I have further documentation that Mr. Rodriguez was presenting it to the town that the sidewalk was his property line and not the property line that we showed you when we were downtown, when my husband stood and I stood, and you could see that the property line is on his stairs in front of his property, if that makes sense.
So if the town were led to believe that his property extended to the sidewalk, might it be possible that the town would then be reluctant to prohibit use of a private property owner's parcel? Whereas if the town were aware that the property line actually extended back, might a different outcome have been
The town
If I may, now we're back to this question of relationship of the pergola to property line. I would be inclined to say that the question has been raised. Either party can provide evidence subsequent to this hearing to back up one or the other's point. And I'm just concerned about moving this process along.
Mr. Chairman,
Now we're talking about water and freezing out.
Mr. Chairman, I fully understand. We'll move it forward, having in mind, I guess we'll have an opportunity post hearing as all parties will. But that at this point, there is no evidence in the record in terms of the application that the applicant owns the sidewalk. So if there's a burden here, it's the applicant's burden. And that might be just something that in the recess memo the district commission consider, and I'll move on.
Thank you.
I mean, I have a question, maybe more for, Quinn, I don't know, because the issue in the photo that we've been talking about is the water flowing onto the sidewalk and freezing, creating a potentially hazardous situation for pedestrians, I think. And the question is that properly considered under the stormwater runoff, or should that be, as was suggested, something more related to municipal?
I can answer that, and
I
maybe,
think you directed the question.
fair enough.
Well, is the stormwater that comes off the roof, creates on the sidewalk, creates a potentially hazardous situation, is that most appropriately considered under stormwater or something under?
My response is
Okay.
where that is placed.
May I respond, Chair? Under stormwater discharge permits for impervious surfaces, all roofs, structures are considered to be a generator of storm water. So when you folks are presented operational stormwater discharge permits, roofs such as the covering of pergola falls within criterion 1.
So, what else do we have under 1B?
Yeah. I'm just making sure that the wastewater.
It's stormwater, yes, under 1B, stormwater.
Yes, stormwater is not.
Well, 1B, the wastewater. No, that's under 1B.
Ron, the letter you were reading from, is that something that's currently in the file?
Not yet.
Okay, so you guys
Not
will
yet,
do that
yeah,
afterwards.
it'll
I
be
just
from
wanted
the
to-
top.
We requested that we
Yeah.
receive.
Absolutely.
And it addresses, as you
Yeah,
know,
just I wanted to.
Yeah.
in much more
Is that
detail.
related to submit or is
You
that a
might-
picture of
Yeah,
property?
yeah, totally fine.
I wrote the letter to Peter when I was on. You might want my letter that I wrote of what I was requesting.
Yeah, that will be uploaded.
They will both be there.
Here's the, absolutely. Yeah.
Thank you. 024I, 2 bathrooms. It specifically states that more than 25, at least 2 toilets, you have to have 2 toilets. Is there any-
I'm sorry to cut you off, but we believe that this is a health code issue. And that involving a number of required toilets. And I believe that might keep it out of our jurisdiction.
Okay,
But,
but having more seats in a restaurant affects transportation.
So, yeah, so
Yeah.
requirements for the number of bathrooms are regulated by the Department of Health,
Yeah.
not Act 250. So,
Just keep the bathroom.
well, and so, but what I did to be clear,
please.
what the condition with that is wastewater capacity, which is
Then I would like to present, exhibit 024W. This will be quick. This is just a long list of Mr. Rodriguez. Water and sewer, zoning administrator in the past, zoning in the restaurant, and receiving Vermont municipal. All I have to say.
So accept and receive. And we have that.
It's like 15, 20 pages.
Yes, yeah, of course, it's on the screen.
And just, if I may, for the record, we will move on. I do think I have an obligation to just put on the record that under criterion 7 on the Vermont Act 250 handbook, it does suggest that the district commission may request information on Schedule B of whether public building permits and Department of Labor and Industry permits have been obtained and whether they're in compliance. So I just,
We can take that up under our
under criteria.
hearing deliberation relative to. I'm not familiar with that, but
Under criteria, under your review of criteria 7.
This is information from 10, 12 years ago, and I object to this kind of information being used to try. This has nothing to do with my application. To you folks, this is something that happened 10 years, 12 years ago. It was corrected, and to bring it in here to try to humiliate me or make me to seem of less character is wrong. This has nothing to do with the application, and I object to this.
objection noted. I can't speak to their intent, but to me, it just looked like a piece of evidence. And it didn't have the reference of its age. Do you want to testify that?
No, that I
Okay,
made my
leave it at
statement.
that.
That was it.
Yes,
Yeah.
okay, all right, fine. Done.
Karen, deliver hand raise, please.
Oh,
All set with 1B.
So in that document, 024W, the last page states that presently Mr. Rodriguez owes $1,343 for water and sewer to the town of Manchester. And then I have.
no, that's not going in the record.
Okay.
That's not going in the record.
Then I have,
Speakers.
would the deck and stairs be discussed now?
Under
If it's.
The director.
Say something.
1B and 4.
1B and 4 soil erosion.
We're talking to talk about the first later.
Then I think I'm done.
See what you want.
Jeannie Cole.
Yes.
I'm actually a neighbor of Karen and Ron's.
Yeah.
I'm neutral. I like both of them. I am appalled. I was a business owner in this town. I own 4676 Main Street. I'm right across from Ron's, kind of diagonal from Karen. This is appalling to me when the town of Manchester has so many issues going on to try and get businesses here. We've got empty buildings everywhere, and we're arguing about a covering that's coming off. I don't understand how it is that Karen, Ron, you guys can't be doing this together, and why the town has to be dragged into this. It's appalling to me. It really is. And issues that are brought up, this is scary for me. I own my building, and if somebody comes next to me and then they say, well, 15 years ago, Jeannie did something to this building. What does that have to do with it? They didn't own the property. You got to deal with when, and Karen, I'm not sure when you bought High Ridge. I think 7, 8 years ago, right?
Maybe the issue comes down to.
Could I, you've made your statement and it's appreciated. The basis of our being here has to do with an after the fact review of work that was never permitted under Act 250. And that's why we're here. And yes, there are a lot of details, but I don't think we're wrongly here.
I don't think
and
you're
I'm
wrong
also
here.
not suggesting, we can't suggest at this point, whether we think all or some or none of the conditions that the applicant is providing us information and that the joiners are providing us, we haven't made any of those decisions.
I understand.
So your concern is duly noted, but not pertinent to this process. And appreciate your having said that. You said it very well.
Thank you.
So,
We're going five.
we're ready for 5. Yeah, yeah. We ready for 5?
Yep.
Yes. Okay.
All right.
You don't go first.
I can go first. Oh, I'm sorry. I forgot.
Matt Cinderbrand. In regards to criterion 5 around transportation, the change of use, from retail to restaurant back in 2013 or 10, I guess. Back in 2010, it certainly did increase the number of vehicles coming to and from, the parking lot. However, between 2010 and 2023, multiple restaurants have operated in that space, right? The entire time. Without issue of parking or anything of that nature. It wasn't until very recently that the issue of the parking being insufficient was raised. This has nothing to do with the change of use. This has everything to do with the fact that there are 8 office buildings at the top of that parking lot, of which there are a minimum 15 cars on. We have nothing to do with the increase in traffic.
So, you're suggesting, not suggesting, you're stating, that the load of traffic and parking on the site, is generated by, other developments, not necessarily, the Rodriguez.
Precisely.
That's correct, and I'll answer the rest of your question. Ron Rodriguez. Historically, those were outlet stores. There was a Claire's there, there was, Jockey, the restaurant existed, for many, many years, and then I came in and I put my restaurant. They coincided quite comfortably for many, many years, and that's for 10, 15 years ago when the town was very, very busy. The outlets were jumping, and it worked. It worked. There was no problem. Unfortunately, or not unfortunately, says, when those offices were, that building was converted into offices, what happened was a lot of them are therapy offices, so they require not only the person who did this, but the client. There are 8 offices. I have a breakdown. There are 8 offices. And if you look at the time frames and how many people are there, it takes 18, and the 2-bedroom apartments. Without the 2-bedroom, it takes 18 parking spaces without their restaurant or without my restaurant. Now, they're allocated 17 spaces, I'm allocated 12 spaces. So with that load, and that's every day, that is every day, and we have the directory that shows all those offices, including Mr. Parent. He has an office there too, the engineer. And that is the load on the parking lot. That is the load also on both our restaurants. So I have 12, they have 17. That leaves them no spaces for a 64-seat restaurant.
May I say at this point, that is all based on an agreement between the parties. Say something?
Just I understand. But
Are you raising, do you have,
You can go first.
I've got,
I'm ready for
Aaron,
transportation.
I have questions for you. Let's take it in order. Let's let them, and then I'm gonna go.
I don't want to go out of order, but I just definitely talked about the changes here, which is mostly what I think. Part- so the property now to, do you know what the first on one of these plans? Is there a number or how many more left of parking spaces required?
You don't have to.
I'm not asking.
So what was that?
So I-
Just speak a little
can
louder.
I,
I can
You
answer,
guys-
I can,
you guys
so,
can see my hand on mine.
Oh,
Yeah. Town of Manchester parking requirements, use of the building as it stands now, the site plan submitted. And the allowable, the required number of spots is 13. Spots provided by the parking agreement is 12. The additional spot, actually 2 spots is provided as per Town of Manchester variance, I would say, lack of a better word, by providing the bike rack, which counts as 2 parking spots. So considering we couldn't expand the parking lot anymore, we provided, as per approved by Town of Manchester, the bike rack to make up for the one additional spot that the change of use is requiring.
if I may, did we? You had.
We're gonna make it-
raised consecutively, is it on the same topic?
well, we're prepared.
No, I'm not talking to you, I'm talking to your consultant.
I'll read this thing.
Okay, because I saw your hand.
Yes, I did put it up for that. Put it back there.
You have that right. You got something to add to your statement?
Just one thing to add. I don't believe the one additional parking spot becomes a traffic issue. We're talking about multiple buildings, multiple comings and goings. I don't believe one additional parking spot for this change of use involves a traffic issue.
So you have, responses on parking?
We do. We have quite an elaborate presentation on criterion 5. And just to preface that a bit is, I'm going to provide the district commission with the agreement for exchange of parking and rights of way of March 9, 1995, and the reciprocal deeds between Factory Direct and M&M Holdings of 1997, who were the predecessors in interest to these 2 parties. And so all the things in these deeds are binding, and the agreement outlining the 26-foot right-of-way with the speed survey is attached to the last page. That'll be, at least in our presentation opinion, is, in our legal opinion, is the legal foundation from which we must commence today. Applicant, under all the contractual agreements, may not use more than 12 spaces. What High Ridge is or is not doing with its property, with all due respect, is not relevant to the hearing today and should not be considered. Mr. Rodriguez and his, whatever may have been there as a prior restaurant is not relevant today. What's relevant is the amount of traffic and trips generated from retail to restaurant, and whether or not the applicant's proposed use can be accommodated within 12 spaces. The attempt to shift this to High Ridge LLC is inappropriate, and it cannot be the focus of the hearing. At least that would be our position. The legal agreements, and I don't know if they've been uploaded. The agreement for exchange of parking rights, I don't have enough for everyone. I'd like to, I think you guys got those, so we can do a couple here. If it's a clean one with the survey attached. Well, I'm gonna add a couple, because I'm old fashioned, I like to hand them to the judges. There's a couple more. Those, that's the agreement, the reciprocal deed. That was the reciprocal deed from Factory Direct to M&M. Here's the reciprocal deed from M&M. Factory Direct using the credit card. These three documents I submit and the maps attached to them are the legal foundation of this entire controversy. And I do have some extras that I can get to you. Quinn, I can give you one more to upload. You've got the reciprocals?
Give us one copy and we'll compare.
Because I saw a lot with markups.
Okay.
I already see it.
Digitally.
Okay.
Thanks for the indulgence to approach the table. I appreciate that. Okay, now in terms of.
Regarding indulgences. The documentation that you submitted has gone into the record. I am not inclined to have a re-speak of what has just been put in the record. If there is a brief summary, and I think we've stated a summary as you were walking across, that you gave your opinion as to the relevance of testimony and your submitted document. So I would want to hear something more than that, but also
Mr. Chair, you run a tight ship. It's not my intention to go through the legal documents.
but
It is my.
What else do you have on file?
It is my intention, though, to present a couple of witnesses and photographs. I first would like to have Mr. Parent, our engineer, speak to the traffic issue, and we have a document that he's prepared we wish to put in evidence regarding trip generation and parking domain. And I've got, do you have enough of those?
I don't have enough for everybody. He has not submitted this yet.
There you go. You want yours? You got yours? They have enough? I'm sorry, I'm gonna follow you.
So, just to be clear for our administrative purposes, I know you guys are doing. Things that. Legal documents there, you just, provided an administrative document, is there anything else? I think that these are right in there already, under zero. Yeah, okay, I just wanted to make sure, is there anything else we should be tracking? Yeah, so those are the two things, very fast.
Karen, would you briefly introduce yourself? These folks have probably met you before. Just give a little bit of background about your professional background.
Frank Parent, owner of long-term engineering. So my engineering company, this is 2008. Now we work for another engineering company for 10 years.
Your credentials are true.
So, Mr. Perrin, were you requested by the applicant and the law office of Salmon and Oster to prepare a parking and traffic summary relating to the change in use from a retail use at 4659 Main Street to a restaurant use? And did you prepare a written document that sets forth your findings and your professional opinions?
Yes. Excuse me, may I suggest that we will stipulate to his credentials and his having been hired and perhaps jump to his conclusion.
Well, that's where we're going. Thank you, Mr. Chair. So walk us through quickly what you found, what you've observed. And I'm really interested, I think the district commission will be interested in noting how many parking spaces are required by a restaurant as contrasted with retail.
So, Manchester parking ordinance, which is attached to the, here by the SBA, and, just going straight by those numbers. Numbers I came up with are a little bit different, but for the current permitted use of 22 seats inside and outside, that's a requirement of 16 spaces per building. If you add in the apartment, which, that requires one additional space. 17 spaces is what's required for the zone. That's for what's permitted, the 22 inside, 22 inside and outside. What we've observed is different than that. I don't know if anyone else counted the outdoor seats today, but it was 12 and 10. And then previous, I didn't come over there and verify, but there are 29 indoor seats, not 20. So if you use those numbers, then the required number of spaces is. So summed up, they need somewhere between 17 and 24 seats, contrasted to the 12 spaces, 17 to 24 spaces as compared to the 12 spaces that they're allowed for the parking agreement. So that's just going by strictly the Manchester zoning ordinance. And on the second page of my handout, you'll see. But then I also looked at traffic, with traffic and parking, which are tied together but they're not. So for that, oh, sorry, yes.
Yeah, you should get that.
Thank you.
Yeah. Let's wait till everything's done.
So that's the, then what we've been observing, actual use of the spaces is that, the occupancy of parking been consistent in the parking space. And that the employees of the restaurant have been consistent in parking, which then means 6 spaces available of the 12 allocated that are actually available to use by that. Traffic, for that, consulted the 8B traffic manual, which is just the standard everyone uses for traffic. And as was mentioned earlier, there's a summary sheet in there. I'm not going to bore you with the details, but a restaurant has approximately 13 times as many spaces as a retail use does. So changing from retail to restaurant brings with it a dramatic need for more spaces. It also, again, I'll just hit the highlights. From what used to be there to the restaurant adds over 100 daily trips, more than 10 peak hour trips during the morning, 10 to 20 peak hour trips during the day. More spaces needed every hour.
I think what I'd like to have you focus on, because it's obviously we want the commissioners to focus on, is your page 1 summary, and the current, the restaurant versus retail versus restaurant. It says peak parking demand. How many spaces are required per hour for the restaurant?
So, yeah, this is based on the peak parking demand based on the Institute for Traffic Engineers is that the restaurant would use just over 17 spaces per hour.
And is the Institute of Traffic Engineer Manual, considered authoritative and the guidance document used by engineers and traffic engineers to calculate parking demand?
I can't speak to everybody, but it's the only manual I've ever seen.
So do you have a professional opinion if this space is converted to restaurant use? Will the applicant be able to accommodate restaurant use with 12 spaces?
Based on my calculations that do not have. The generated use requires more parking than they have.
Okay, I don't have any other questions. Thank you, Frank.
I have one question, but I want to defer to both of you before I ask it. Do you have any questions or comments relative to 5 and traffic and parking?
The only, I guess the only question, just for clarification, you said demand of peak hour demand for a restaurant? And is that, are there multiple hours during the day, or is that?
Yes, so that's the peak demand. And the peak hour is different for every business, but that's just at the highest use, they need
Do you know when that would be, that hour?
during the time.
I may have that too.
So, the peak demand is different whether it's a weekday or a weekend. Highest hours are between 12 and 2 for lunch, and then again, kind of 5 to 8 for dinner.
And
It
is
depends on.
the peak hour demand the same for the lunch business as the dinner business, according to your manuals?
So this has 100% peak demand at noon during the week. And then at dinner, it ranges from 5 o'clock, 46%, 6 o'clock, 77%, and then drops down a little bit.
So the peak hour then that you're saying the 17 is the lunch hour?
Yeah, right. Yeah, we think of peak PM hours as late in the day, but in this case, the peak PM hour would be the lunch hour.
On weekday, on Saturdays,
Yes, on Saturday, it's later.
on Saturdays, it runs from 5 to 7, 5 to 8. You have this? That you're looking at? I don't think they might want to copy of this. It's this commissioner requested. Yeah, let's put this in evidence. The 932 ITE. I'll bet you do. Yeah.
You completed your presentation. Yeah, only to add that, the thing for the zoning. That's also number of parking. I don't know what the ratio is, but that's in there.
All right, thank you. I have a question that could be answered by either party. And it doesn't necessarily bear on what decisions this body will make. But can either of you tell us what the local review process, the opening of the restaurant was? And did it address parking?
I'll answer
Yes.
part,
we'll
and
take
perhaps
it-
she
we'll
can.
take- No, we'll take it from the,
Absolutely.
yeah.
While the town has ordinances for
Mhm.
parking,
Yeah.
there's been a big contention of how Manchester handles its parking.
Mhm.
And for several reasons, this town has shifted. It was an outlet town. It was very just,
Yeah.
commercial.
We kind of know all those facts.
Okay.
What
So,
I'm
The
getting.
process,
If I may,
Yeah.
what I'm getting at is, can you give any evidence, either of you, of any decision which was rendered by the town relative to parking, I'll get to you. Relative to
There
parking.
has, no,
Do you have any evidence relative to that?
Mr. Rodriguez filled out his application. The zoning administrator approved the application. Zoning administrator didn't have the authority on his own to approve the application for changes. It needed to go in front of TRP because it was based on a shared parking lot. That never happened. Then the owners of the Little Rooster at the time sent a letter appealing to the DRB. The zoning administrator not pass the letter on to DRB. The zoning administrator sent out the letter saying that they can choose trees, they can open up whatever they want. The Little Rooster people didn't understand that there was this parking agreement, and the original parking agreement emphasized that this building is supposed to be. Never said that. So Mr. Rodriguez opened up with 10 seats and increased it slowly. So the demand for parking changed significantly over that time. If you have a 10-seat ice cream store and now you have a full service restaurant with takeout, like that's a significant change of use.
Okay, thank you for that. And as I said, those positions do not bear totally on our review relative to parking and traffic. But I appreciate the background. Is there something more?
No, just to clarify that, I didn't get it here for you. I don't know what the agreement, what was proposed in the permit. What I looked at was the current zoning.
Understood, yes, and I think you said it.
So,
Ron,
Mr. Chairman,
you were, all three of us had your hands up.
Yeah. Did you want to comment on the parking?
I just wanted one question to Frank. In his experience with the town of Manchester, have they ever asked or has he ever designed a site pursuant to the ITE parameters instead of or in addition to town of Manchester parameters? Because it would seem like we'd be going above and beyond.
Yeah, so no, the short answer is no. When we design a parking lot, the number of spaces are for the town ordinance. I was giving testimony kind of on two different things under criteria 5, both the parking and traffic impact.
Yes.
But yes.
And then to follow that up, the application in front of you is proposed 32-seat restaurant, 10 outdoor, 22 indoor. Once it's approved, then enforcement would take over. And if he's got more seats outside or more seats in front, he's paying a violation. He's getting slapped with a violation. We're trying to get to that point. So, whether he's in violation now, he probably is because none of it's approved to begin with. And that's why we're trying to clean all this up. So what they observe or what goes on day to day, the proposal is in front of you of what he's asking for after the fact.
and just one thing to follow up, the letter that, Aaron, speaking about, that went to Lee Crone, who was the zoning, manager at that time. And we went to the town and we paid the fee for the seats. They were approved by the town. You had asked me that question and I didn't answer. It was approved by the town. We went there, we said this how many seats, we added, as she said, 10, we added more seats. We went to the town, we paid the fee, the water and sewage, and that was approved.
Okay, thank you. Something new, Aaron, or?
Well, I've got a question. I still have questions of you, and then you get a chance to run. So, and then I'm gonna bring you back when we talk about the deck and the encroachments.
But under the violations, it specifically shows that the zoning administrator would go in to Mr. Rodriguez's place, find 12 seats. He would get a violation, then he would have to increase and pay the additional water and sewer.
Okay,
So
get your point. And so,
May I continue now with the witness?
let me think about it. Yes, please continue.
Thanks, Mr. Chairman. All right, so Karen, you've heard Mr. Parent's testimony. Now I want your testimony to focus on a few areas before you go with what you wanted to present. I want to focus on what you observe day to day involving the present use, so we have an idea what conditions this commission may deem appropriate. With respect to the present use of the parking area, what has been your observation about the number of spaces occupied by the apartment or the top floor residential use tenants?
There have been 3 cars in the parking lot consistently since December 25th. Since January of last year, there were 2 cars consistently.
So for the last 3 or 4 months, 3 spaces for the upstairs folks.
I know there's
Okay. How long has there's a Volkswagen parked with flat tires out there? How long has that been?
July 4th.
And if you've got 3 per apartment, how many spaces are used by the restaurant employees?
So from the time that they opened, August through October-ish, there were consistently 3 employee cars there every single day. Presently, like since it's slower, there are consistently 2 cars there, and sometimes there's up to 3. I'm assuming if the summer comes back, there will be just 3 cars. We have 7 employees working in that small.
How many ADA parking spaces are in shared parking area?
There's 1 that's allocated to our restaurant.
And so if this commission determines based on evidence that will be presented that 2 are needed. So if you got 3 for personal use, 3 for 3 for the apartment, 3 for employees, 1 a disabled Volkswagen, that's 7 spaces. From 12, would you agree that leaves 5 spaces for the restaurant use?
Correct.
Unless this commission in its wisdom chooses to condition a decision stating that all spaces must be preserved for the restaurant, no employees have to park off-site, apartment owners have to park off-site, that type of thing. That's something they could consider, correct?
They can't consider the way the town zoning is.
Okay.
The closest public lot is 1,500 feet away. Mr. Rodriguez tried to use that woman Jeannie's lot. The DRV shot that down and said that parking lot was 500 feet away, and they refused to allow that allocation with safety measures with sidewalks and stuff. I've contacted the Hampton Inn and the Gap, and both of those facilities who I have rights with will not allow Mr. Rodriguez's property to allocate our parking that we have allocations to at those 2 facilities.
So is it your testimony that even if this commission wanted to?
If I may?
Yeah.
I think there's a lot quicker way.
Yeah.
For you to say that in your opinion, there's not enough parking. And I almost, I'm almost upset that we're playing what I call a game, to say things, and I'm not being personally critical here, but time is a commodity, and your method of providing us with facts is difficult from this side of the table.
Fair enough. Just trying to provide enough evidentiary foundation for you to make an informed decision and create a record. So
Appreciate that.
But
I would say that you've been successful, but hopefully these two
well, we'll move on now. Let's take that into account.
Thank you.
I mean, if I may, if you could probably state pretty succinctly how many parking spaces are required if you haven't done it already versus how many you've provided. And leave it at that. I mean, I think I've heard your engineer and I've heard, Ms. Garriak both testify to that. I think just like one summary statement
Yes.
would do it.
Well,
And
fair,
we can look at the foundation for it.
all right. Well, I think that's fair then. I mean, what, if, that's helpful. Some commissions would not accept the memorandum without the backup of the testimony. So that's what I'm trying to do. Every commission works a little differently. The summary statement is given, Mr. Rodriguez's present use of the property for the employees, the apartment, disabled vehicle, and allocating one to ADA use. The restaurant should be limited to no more than 13 seats total, because he only has 5 available.
We'll take that.
Okay.
Yes, but that could have been said. What else do you have on parking?
Well, what else? Again, so we have data, the ADA regs, but you folks are capable in terms of ADA, the number of handicap spaces required for more than 25 parking lots, 2 spaces. That's our statement. If you require additional proof on that, we have. Okay. The applicant's rear deck and construction, it's our testimony, Mr. Parent could present, and we do wish to put in evidence the site plan based on the SPE survey, showing that a portion of the deck and the steps encroach within the 26-foot right-of-way. Would you like further clarification on that?
I think that we can accept that. The only thing that I might be inclined to want to know from your perspective is, could you explain to us the severity of the impact that caused?
Deck encroaching on the parking spot?
I assume it's related to movement of traffic and parking of cars.
Well, Mr. Rodriguez now removes his parking spot.
No, I'm not talking about that right now. I'm talking about, he began to talk about the encroachment of the deck structure on the driveway. And so we stipulate that and would like to hear your views of what hardship that has created.
If I could just add to that a little bit, there's a lot of talk about. And I think, and I understand, I believe, but what I just compare functionality is that 26-foot right of way specifically like a area for vehicles to drive through the parking lot. It's not actually including any of the area that's dedicated for parking cars. It's just 26 feet is where the vehicles are supposed to operate to get in and out of the parking lot.
The legal, I believe you're correct.
Yeah.
The legal documents that you have that you can review in your own time provide for an unobstructed, unencumbered 26-foot wide right-of-way. Our client is insisting on that, regardless of how much encroachment there is. She and Mr. Parent can talk about the reasons why that's a problem with the deck and snow removal and the car part here not allowing people to make the turn as historical because you go right up to the line. Those kinds of things we could go into in more detail. We showed where the car is parked today, where it's over the parking space allocated because they want to put a bike rack in front of it. They're not legally allowed to do that. That in a world where we're writing on a clean slate, it might be something for the commission to consider. These folks, because they had a shared retail use in the early 90s, had lawyers in this town prepare very complex legal agreements, binding upon all successive owners, perpetual. It said perpetual and binding on the land forever. Those are the documents you have. I can sympathize to some extent with Mr. Rodriguez trying to operate a restaurant within those constraints, but that is the reality of the property he purchased.
So, what you're telling us is that the issue is, the historic agreements, and you're not making an argument based on current functionality.
It's both because the encroachments do interfere with our current function and use.
You have something more?
Just to, I think the more to answer your question more. Approaching impact the circulation of parking lot, a couple of ways. One is if you're trying to back out of one of those spots. It's more difficult because you don't have as much room for that. The other is when you have two cars passing, there's just not as much room to go off. Wait, someone come around before you can get up the parking lot, they can come down. Or there's also a lot of deliveries between the two buildings. Get food trucks, and they'll park, and that will make it hard to get around. So the reason we want that full 26 feet is just.
So I just want to understand the strategy. I understand the point about I think 26 feet is wider than standard. And so the question is that I don't, 26 feet, I get the agreement. I don't know, maybe that's needed for maneuvering for deliveries and things like that? Is that I'm just talking functionality.
Yes, that is part.
Are there like deliveries to the restaurant where vehicles have to back in and out?
Right, the difference being, I think to your point is, when you've got two cars passing on, 24-foot wide road, you've got 12 going this road, 12 going that. You might have to slow down as people turn in and out, but you're not maneuvering around stationary park objects. You're not trying to back out into that space. You're just going straight. Now we're trying to either back out of a parking spot and there's things in the way, there's people coming through. It's a parking lot, not a roadway, and that's the difference in front of that.
Do you have anything beyond the restriction of the lane?
Is it allowed to be restricted?
I asked if you had anything else to testify on relative to the restriction of the lane.
How about snow removal?
This, yes, and he has cars that park in that lane, and he's been doing the construction, so literally there'll be a Miles van there for 6 hours while they're operating inside, and your vehicle's trying to go around Miles van or the non-car that parks along the back of the building. Very difficult for cars either park in the parking lot or witness like a large SUV and then like a FedEx truck. They're usually gone quickly, but you also get the Miles vehicle with the plumber that shows up and they have to go on. So
We hear what you're talking about.
and
Are we prepared to move on from the
Do you want to
issue?
You want to just, if this is on the obstruction issue or still on?
I just said, are you prepared to move beyond the 26 issue?
Are you? What else do you have?
so I'm just gonna go through my exhibits very quickly. I'm not gonna give you a detailed explanation. You have them all, then you can review them. Okay, exhibit 024P just shows the NOV and that Mr. Rodriguez was supposed to remove the planters. He removed the planters and he put his Volkswagen there instead. Then exhibit 024K gives a very quick thing about the bollards and his car, and that the town they're not allowing permitting of 6 parking spaces. I mean, a 6-unit bike rack for 1 car space. The Greek restaurant just attempted to use this and it got shot down by the select board. They don't think Mr. Rodriguez has a permit variance from the town. Then it's the ADA parking space would be folder 9024M. Exhibit 024N, folder 9 is very specific. The parking, the allowable seats based on parking agreement. You should only be allowed 13 seats in those spaces. Exhibit 024T goes into the outdoor seating. And that was an it gives you the incentives that the town of Manchester used at the time. The incentive was that if your neighbor had parking and they were willing to share their parking, then you could have the outdoor seating without having to require parking. Our parking agreements never changed. We never got additional shared access to a monster. Exhibit 024U is just the non-open. We were fearful that it was going to be a very busy restaurant because they have an additional restaurant in town. It is a very busy restaurant. On top of it, they have a van that they produce food at one restaurant and bring it to the other restaurant. Literally, it's me standing at the window or the door, counting cars, physically counting cars. You can actually watch if they were coming to our restaurant, or if they were going to Nam, or if they were going up the hill. Then exhibit 024Q is just when it's very, very congested, and we had counted the cars and knew exactly how many cars were in our place and how many cars were next door. Zero.
Can I slow you down?
Just
for a minute, just ask a question. Because what they'll be having, the commissioner's gonna be looking at a lot of photographs showing overcrowding and the full parking lot. How did you determine the number of cars that were using Nong's restaurant as opposed to cars possibly using High Ridge Plaza facilities?
Standing at the window or standing outside.
And if they walked into Nong's restaurant, how did you track that?
It was done at 2:05 cars at 2:05, 14 cars.
And is that all documented in your exhibit?
Yeah.
Did you personally observe the traffic?
Yeah.
And you made the data, you created the data.
Yeah.
And you're testifying that that data is accurate.
Yeah. Our other attorney told us documented. Typically, that was the report. Then, Mr. Rodriguez, please exhibit 024D. Mr. Rodriguez, on June 1st and 2nd, I think it was 2023, he held a motorcycle event. He didn't contact us. They basically put up the whole parking lot. So it's just pictures of that. 024L exhibit is just about the ADA handicap parking fire safety 29-inch bench. You can't get in the back door. I think that's the transportation. Okay, thank you.
Good
Thank
job,
you.
Karen, thank you.
Yes. Well, you're going to give you the opportunity to rebut if that's reasonable, but
This is the course that we're going to take.
Can you just, yes.
We're gonna help.
This is the course that we're gonna take. We're gonna take this. This isn't a murder trial. And what's going to happen here is that I can rebut everything that has happened here that's been said. Just an example about the parking and that car, it's there. This is my application and I just want to say why that car is there, because it'll sum it up and I'm gonna stop at that. That car was there because after the planters were moved, we had planters there. After they were moved, and it was as Chris Kinnick enforced me to move the planters, the space was open. Mr. Dworkin parked his big truck there in order to stop the access of people into the restaurant. We're going to send you pictures. And that was the reason why we put that there specifically off to the side to allow an alleyway for the car, people to walk into the restaurant safely, that they wouldn't have to walk into the oncoming traffic. So there's a rebuttal to all of this. And
Thank
I'm
you.
just gonna let
Thank
them
you for
make
that.
my case for me, and we will send all our stuff when the time comes. So we're really pretty much gonna keep quiet right
That's your choice. I'm not asking you to.
now. No, I know that, but I don't want to go on until tomorrow. I don't want it to be a bickering back and forth, and that we have rebuttal to all of this. And this is not a complicated case. We're gonna say, well, listen, they can make their case, they can say what they want, but we're not gonna do that back and forth, because we can do that and we're not gonna get anywhere with that. They submit their evidence, we will, and then folks can make your decision.
Thank you. Where are we at next?
So
Are
I
we,
guess sorry, are you,
if you're going to leave, traffic, if we're going to move on, just want to make sure, Quinn and Mr. Chairman, that then we're in agreement without having to have Mr.
Evidence, the survey showing the 26-foot right of way and encroachment to the other site plan that we brought for illustrative purposes. Would those be acceptable? Leave them here. Do you want them up there?
no,
Sorry, what?
you have.
Surprised you don't have one for everybody. I think it might be.
Okay.
This one here, the last. This one showing the foot. That's the electronic. I'm gonna leave both.
No, but you have it electronically in a manner that it can be presented to us. That's what we're.
The last, whether we can send it to you.
Yeah.
I'm still gonna leave that, the hard copy, and we'll send it.
I guess I don't. Criterion for this application. Criterion 5A specifically focuses on the congestion or unsafe conditions with respect to highways or the roadway in this particular case. Do you all feel that you've heard enough about the items that have been presented specific to safety and congestion?
I think that the trip generation information was sufficient for me.
I just
Yes.
wanted to make sure just when we're in deliberations. Okay, excellent. Thank you. So I think your next criterion will be 8, aesthetics.
What you have to present.
Matt Sundgren for the applicant. It's very clear when you look at the two properties, which one is more aesthetically pleasing. If you see, the modifications we've made, they have been aligned with the aesthetic beauty of the area. That's all we have to say.
Trash cans under that?
You're right with you.
Yeah.
Sorry, what was it, outburst?
No,
They don't have to say more about it. That's what they chose.
Yeah, yes, okay, all right. We're on aesthetics. Who would like to, do you have input that you're offering on aesthetics?
my summary statement, Mr. Chair, would be that the physical alterations, including the deck and the stairs, are not compatible with the building's historic qualities, and adversely impact the historic character of the building. Karen has some photographs that may illustrate some of the other uses.
0248. Knows all the top of it, damaging it. That's why he redid the bill now. So I just, there needs to be a better situation for the garbage. There's pictures of it in a meeting about
So if I could. So this is the current condition as part of this, proposal, the applicant is supposed to for the,
That was 2 days that was there because of what happened.
Yeah, I know, I want to.
Yeah. So, yeah, people look the site plan. The name of the area was, that's built from, put in to, cover that area.
Did you point?
Okay, here's what it's gonna look like. And here's where it's gonna be. You can see these three little cans right here. It will surround that area.
Okay, thank you.
And that's where they are historically. Those cans are always there. They just happen to be those 2 days. But because there was snow to make it easier for Casella to take them out and not leave them there.
Mhm.
And that's where they've always. That's the proposal to at least block that and make it even use over the cans.
The proposal is aligned with the recommendation that
Well, the handicap, I'm sorry, I believe that comes under building permits, like safety codes and ADA compliance, which the commission have to consider under criterion 7 municipal, but we don't have party status on that. And I think that's why we're moving forward.
Okay, thank you.
There's, to summarize, that the criteria 8 concern was just specifically limited to the trash can.
No, the criterion 8 concern is the deck and the stairs and
The
both,
deck.
yeah, the deck and the stairs in terms of the physical alterations to those are not compatible with the building's historic qualities. If you had we don't have with us today a historic preservation trust person. They did reach out to me and we may be able to provide a post-hearing letter.
I think there has been a letter.
There's a letter from the state historic.
0223.
Thank you.
Okay.
Yep.
We don't have anything else on 8.
Okay, all right. Yeah. So, you did a presentation at this point.
as stated in, sorry, as stated in the kind of opening testimony, the current liens placed on the property for maintenance of the shared parking lot are in dispute. And often stretch beyond the scope effort.
Your
Maintenance of the shared parking lot being a public. Sure the public facilities not being public.
Well, no, that's out of order. So that's the one thing that. want to address.
Yeah, just in addressing the memorandum of comments.
Yeah, yeah. Anything from the others?
Also the insurance policy,
Well,
since 2018.
The summary, the summary of the response, Mr. Chair, is, applicant's change of use has substantially increased the traffic flow, which has contributed and accelerated the need for parking area repairs. The applicant is responsible for 41%. It's outlined in the documents earlier provided to you, the agreements and reciprocal easements. It's the testimony of the applicant that those expenses, the 41% share now exceeds $20,000. And until that's taken care of and until applicant is asked to contribute to the future repairs required due to the deterioration observed today, that the applicant's not able to go forward with necessary parking repairs. So that's under maintenance, under 9G, that's the issue. We're asking that the applicant either become current or post a surety to help cover the necessary repairs, which is under 9B. And there is, I believe there's language in the agreements that High Ridge Plaza, since they were the 59%, the agreements provide that their choice of repairs is binding. But we'll have to take a look at that.
A question that well, I'm going to direct this everywhere, but I'll start with you. Is it your opinion that that agreement between the parties is a 9G Act 250 what's the word I'm looking for? Is it what issue? Or is it within our jurisdiction? Are you saying that it is? Are you saying that it is an Act 250 issue?
I am. In fact, I'm involved in a case in Killington right now with a private road. And it was required there, at least the commission seemed to suggest or require the applicant to enter into a shared maintenance agreement or provide surety. And it was clear that 9G was indicated even when parties have private arrangements, whether it be there's a Hawk Mountain case where there's a septic system. So the
Question was.
The answer is yes.
Yes.
The answer is yes. We believe it's a 9G issue.
Yeah.
Well, not only not abiding by it, but if the town, for example, if they just choose not to, what happens to that site? And that's the same thing like private shared wells, private roads in subdivision. So if the town of Manchester, in other words, 9G in part protects the town of Manchester by requiring the applicant to provide a surety to the town. If he's not going to provide it directly to High Ridge Plaza, he could provide it to the town.
But the agreement is in place. to
It-
allow for that to happen.
Surety to the town's not in place. The obligation to maintain is in place and the obligation to pay is in place. But how does Act 250 step in when a party doesn't? And how do they assure that these private utilities will be maintained and not become a burden to the town?
That's a helpful distinction, thank you.
Additional response from the applicant?
But just, yeah, cause this one's a little bit, one I haven't dealt with a lot. That, how do you see this, if non-compliance with this agreement or becoming a burden to the town?
Well, it's the same with like private septics and condos and things. If those fail, people stop maintaining the roads, municipalities generally get sued if for some reason and say, why didn't you step in and why didn't you make sure this wouldn't happen? And in order to protect that 9G said, we're not going to step in when common roads, wells and things are maintained by private parties. Make sure you protect our interests. Same as a private septic in the Hawk case, there's precedent that says, yes, the town in that case was asked to come in and make sure that they provide some
Well,
means.
if I
Yeah.
could, let's talk about parking lot, because the
Yeah.
private septic failing is gonna potentially have offsite impacts. So I can understand that, but the private parking lot,
Well, what if one of the tenants, again, I guess I'm trying to be creative here for you.
don't be creative, just be pragmatic.
Well, if I were a pragmatic lawyer representing one of the tenants, I might well bring an action against both tenants in the town. If I can't access my property and it's gone to pieces, in terms I can't access, it's hurting my business. Why, didn't Act 250, why didn't the town step in when it could have? That might have been something I might have done. If you gotta do that. Is it a far reach? Is it clever? Is it creative? I think that's why 9G was put there.
Don't think we're
But
to the
it,
sign just yet.
no, I know, but it has to do with transportation. If the sign stays in that place, you're going out, we could get sued, Mr. Rodriguez could get sued, and the town could get sued, because the town would get sued because they allowed the sign in the public right of way.
Quick question. To the adjoiners, attorney, in your experience, how many sureties does the town of Manchester now maintain for parking lots within the town of Manchester? Private parking lots.
I don't know that. I do know a number of towns have shootings, but I don't know about Manchester. I cannot answer that.
Do you have other redress other than through Act 250 on matters such as this?
Absolutely, Mr. Chairman, there's no question that High Ridge can engage in private civil litigation with the applicant without a question. That's available. And
We'll
Mr.
take
Chair,
all of that into account.
yeah, and as the district commission must weigh as you deliberate on a party status, it's my job to make sure to protect the record here and that all potentially impacted criteria are addressed. But we do have other remedies.
Okay. You had that comment, and anything else relative to this matter?
Nothing.
Okay. So does that bring us to 10? Does.
I think, sorry, that's under Brand. I think in terms of criterion 10, this is really for the town of Manchester to determine the local and regional plans. And the fact is that even with High Ridge's continued efforts to pull the town into discussions around the viability and verifiability of the permitting, inspection, and certification processes, they have been met with a resounding, no, everything's okay. So that's all we'll really say. The town is completely aware of and good with everything that has been done on the property and everything that will be done on the property to remedy some of the, let's say, standard infrastructure issues that happen with a building that's, from 1842.
And Ron Rodriguez, I'd like to add to that, there some certificates that are out, and I'm sure they're going to bring them up. And I met with Peter Bravazon, and we've made an appointment to close out those certificates, whatever's outstanding. The burns have been met, and he's going to close them out. Only we have put our paperwork in. There's an appointment that's set up. Those will all be closed out. So we have no problem.
Criterion 10, the summary statement is set forth in part on page 13, 14 of our memorandum. We refer to the town plan, particularly when we talk to shared parking. We've got to acknowledge the actual on the ground needs. And our comment under parking and the town plan would be when you have a legal document which creates a parameter which cannot be exceeded of 12 spaces. And when you have that as the backdrop, everything that happened before or even existed is irrelevant until the applicant can demonstrate that they can operate a restaurant with 12 spaces. And if so, then this commission has to decide how many seats would be allowed in that restaurant. And the evidence from our our engineer and the ITE studies, given the present use, the on the ground usage, that this restaurant would have to be limited to 13 seats. And then Mr. Rodriguez will have to decide whether or not he wishes to continue the restaurant or convert to retail, because there was no vested use. The property owner never had a right to convert to restaurant in the first place. And the town not being fully aware of the legal documents, and frankly, until our office got involved, and I don't mean to seem clever, and I don't mean to seem smooth, but when a legal document comes to my attention that sets the boundaries for all the municipal bylaws and ordinances in Act 50, I had to bring that to the attention of this commission. And I think that's what you folks have to wrestle with. Where does that fit in? The legal parameters versus the Act 50? Because if you were writing on a clean slate today, commissioners, this might be a totally different outcome. But you're not.
Thank you. Karen, did you have anything else you wanted to offer?
I have one other point. When we were talking about the kitchen expansion, if you can just pull up 024I. I know I might be going back a little bit, but I just want, while you're here.
That's the 2 bathrooms, is that?
024I, I think it is. Okay. The kitchen expansion.
That must be a different number.
That's page 4. Keep going. There. That was what he proposed for his kitchen as expansion. This document is his permit. And as you can see, that's not what was at the site today. And then if you go further down, you're gonna see the old, keep next page. Keep going. Keep going. Keep going. There's where the Ansel system had been for about 10 years. It was under his wooden deck. And you can see the grease going down it. He got shut down because of that, and fire and safety and NOMS had to take over, and they rebuilt it up to the top.
I didn't get shut down. I was closed. The restaurant, we closed the restaurant. We did not get shut down.
I'm gonna come back to you.
All right.
Okay, yeah, Karen, continue.
Go ahead. I think go a little bit further. That just tells you that when he did his kitchen expansion, he was supposed to use an architect for plans. And Mr. Keela is the gentleman who did the plans for him, and Mr. Keela is not a licensed architect. That's it.
We went to the town. We thought we were gonna expand the building. We got a permit for that. We never did it. We chose not to do it. Wasn't mandatory. We chose not to do it. And the reason why we chose not to do it was we didn't want to ruin what the building looked like so many do to buildings, and old historic buildings. It's a nice looking building. We maintained it when I bought it, but the roof, and we'll fix the roof. It has plate, has everything in order. So we decided not to do that. And that's why what we did was we just put a walk-in, and the walk-in is actually under that deck. And that's what we decided not to enclose it, not to change the thing with the foundation. There's a full basement downstairs, and we kept everything intact, and we chose not to do that. And when I decided last year to retire, I closed the restaurant. I was not closed down. We did not get closed down. I closed the restaurant. We made all the alterations that needed to be done, and we sold the space. And everything is under compliance right now with fire and safety, with GJ Garrow, with everybody. Everything is in order.
Thank you.
And as a couple questions. So all this, the most recent discussion here about the permitting and the addition that wasn't built, now that was all related to town permitting?
Mm-hmm. And then he never got it back to good.
Okay, but correct. So, and then I just want really quickly on the town plan stuff, because we talked about that. So the town plan in Manchester, I know deals with, responsible, careful commercial development, respecting the neighborhood and neighbors and all that. It also is very aspirational for shared parking and the park and walk concept. It doesn't go into a whole lot of specific details. Do you think that the town plan is clear, prescriptive enough to allow you to just rely on the town plan, or should we look at the land use regulations to provide?
Needs to look at the zoning regulations. The town of Manchester has evolved and changed. So when our complex was built, we, the Shallots, had to donate like $105,000 to this walk program. In 2014, the park and walk program was shut down. It doesn't exist in the town anymore. Now they're attempting at this point to try to revitalize it. But the issue if you have, and I have all the big landowners, I got the Hampton Inn, I got the Northshire Bookstore, Walgreens, Green Mountain Shops. Everyone's angry because the way that the town has evolved, they've allowed this kind of permitting to happen, and there is not enough parking in the downtown Manchester.
So now you have the Green Mountain Shops. He has just started this $3 an hour parking. Walgreens is now towing because the town isn't sitting down and talking to all these individual property owners. Northshire Bookstore is pissed because on a regular basis, they get vehicles dropping, people will drop their car there for the weekend. The same with Langway. So we have a real parking issue in the town of Manchester right now. And if you look at newspaper articles, it's being dealt with because you're getting uproar from business owners who are tired of it.
Got it.
I'd just like to respond to that. This town is a very unique town. And because it is a tourist town, it changes and we're seasonal. If you go to either one of those restaurants this week, there was nobody there. There was nobody in that parking lot. And that's the way it goes. You know, your summer, you get foliage, then you have November, it's empty. And depending on the weather, if the weather's not good, people don't come up to the hotels and all things. So the parking in this town, to answer your question, is fluid. The town understands that. The select board does that. And they really try to accommodate. They don't want to make parking restrictions just like you go to Woodstock or other towns where they, or Hanover, you know, they charge for parking. They want to make it that it's easy for people to park because they know that sometimes they may park a car, they'll walk to other places, sometimes they'll drive around. And so in a place like this that relies on tourism, almost like the state, they have to be very flexible. And what was good 2 or 3 years ago isn't necessarily good. And they're trying to figure it out. They're wrestling with it. But the bottom line is at the end of the day, it's almost like you have to accept first come, share, you have to accept that. And that's the way this community in this town works. And that's the way it's always gonna have to be. Because if you go ahead and you say, well, you can't park there and you park there and everybody's like, nobody comes. It's inconvenient for people. And to answer your question, the town is looking for solutions, but in the end, what do? You have to be flexible.
Did you have you had your hand up first and then.
I just wanted to mention real quick, state of Vermont recently mandated that throughout the entire state, each county needed to start producing lower income housing. Okay, certain number of units per county. Here you have a landowner who did create an apartment in the middle of downtown. So it kind of goes to that. Obviously, he didn't know that was required back then, but it's again, something you're kind of moving towards what the state of Vermont is looking for you to do and help out doing. So,
Karen.
The Walners had an apartment there. So back in 1995, it was approved for an apartment upstairs and then it got converted to 2 retail, 2nd floor and 1st floor. So that's misinformed.
Was that improved by Act 250? Sorry, I'm done.
I was just asked about the town plan.
Yeah, yeah, you did. Yeah. I'd rather not get into a back and
No,
forth.
that's fine.
Oh,
Yes,
yeah,
do.
you're right.
Factual information.
Yeah. Did you have something? It was a while ago.
Yeah, no, I guess, I don't, does anyone else?
Yeah, I wanted to pick up on
I guess,
your hand wave.
Yeah,
Guys,
yeah.
Do you have anything else?
No, I want to thank them. A lot of input. The file is full. You've made promises to update and add to those files. I'm very anxious to get it. I need a couple of days to sort it out.
More than that,
Yeah.
probably.
But excellent presentation. Thank you very much.
I keep looking back there, and this is a compliment. We all remember the last time we were together, and we were in that closet. And it was
We were on
not,
10 more people.
yes, and it was not a good experience. Sorry, to a certain extent, I just want to compliment you all that we accomplished a lot more today than we did in that rancor that was in that room in that last hearing. And I blame the room. I blame Manchester for sticking us in there. But that's a fact. And so, I also want to thank you for the job we have ahead of us. Because this is pretty complex. And one might not think that it is, but it is. And we'll do our best. And we'll get back to you, as they say.
Thank you, Commissioners. Are we done?
So just for a procedural point, to
Yes.
put a little bit more specific on that, the next thing you can expect to hear from this commission via our office is a hearing recess order that may request both additional information from the applicant and or the party. But also when that is issued, there'll be a deadline for that information as you see fit, even if it is not specifically requested in the hearing recess order. And then moving forward from there, the commission will issue ones or, indicate once they have a complete record that they are considering. So.
Thank you. Y'all want to go have lunch? No, that's an independent, you guys can go have lunch. So, I guess we'll call this hearing, recessed. And, as, you said, we'll continue to do our thing. Thank you very much, everybody.
Thank you.
Very kind
Thank
of
you.
Thank you.